Is there such thing as child abandonment in Alabama? The short answer is practically there's not really a thing called child abandonment when the father or the mother steps out and something significant happens legally. Unless you're going to file a step parent adoption. If there's going to be a step parent adoption, that changes everything, and abandonment is important. But we do have code sections that deal with child abandonment in Alabama, and I'll go through those and how it would affect your case. I think the most frequent question we get is, can I terminate the other parent's rights because they have abandoned them? Here's the code section for grounds for termination of parental rights. And this is the section here. It says abandonment. It says something a court, in determining whether or not parents are unable or unwilling to discharge their responsibilities to and for the child, the court shall consider, and in cases of voluntary relinquishment of parental rights may consider, the parents have abandoned the child. That's the first thing. And then here, in any cases where the parents have abandoned a child, such abandonment continues for a period of 4 months next preceding the filing of the petition. Such facts shall constitute a rebuttable presumption that the parents are unwilling or unable to act as parents. So that's huge. It says 4 months unwilling to act as parent. We have a new 2024 case called JA versus SL that says even if the dad has abandoned the child, that doesn't mean that the termination of parental rights should go through. Okay, so here's my summary of this case. It shows that they went to court. The mother had shown that the father had not seen the child for 10 months, didn't pay any child support, and the court even found that the father abandoned the child. He then appealed after his rights were terminated, and the Court of Civil Appeals said that the juvenile court erred in terminating the father's parental rights because it did not serve the best interests of the child. In Alabama, it requires that termination to be in the best interest of the child, particularly where termination would provide security, stability, or adoption prospects. That's the key right there, is the adoption prospects of the child. The appellate court said that since the child was safely residing with the mother and no adoption was planned, terminating the father's rights did not further the child's welfare. The court highlighted the termination of parental rights as reserved for cases where it benefits the child's need for permanency and stability, which was not the case there. So everything is different if we are talking an adoption. Step parent adoption makes everything. So based on that case, I'm not going to tell you that a parental termination, parent per parent, can't happen, but it makes it very difficult based on that case. If there's a step parent there and that step parent is willing to adopt, that completely makes everything a lot easier to get those rights terminated. The law says about adoptions, it says that if the parent abandoned the child for 4 months preceding the date of the filing of the petition, that they have impliedly consented to the adoption. Makes it a lot easier for us to get that done, and that's the easiest way to handle abandonment, is with a step parent adoption.